Is every person born in India automatically an Indian citizen? Does marrying an Indian citizen automatically make a person an Indian citizen? Is a child born abroad to Indian parents always an Indian citizen? The answers to these three questions may surprise you, because Indian law applies different rules to each of these situations. Friends, I am happy that our channel has completed 1 lakh subscribers and has received the YouTube Silver Creator Award. Thank you for your continuous support. For more legal awareness videos, subscribe to the channel free of cost. You may also support the channel by taking a membership of 59 rupees or 119 rupees through the GPay QR code displayed on the screen. Now let us move towards today's main topic. In today's video, we will understand, on the basis of Sections 3 to 7 of the Citizenship Act, 1955, what the only 5 legal grounds for becoming an Indian citizen are. Whether you are a law student, preparing for competitive examinations, or simply wish to understand this subject as an informed citizen, this video will be extremely useful for you. Introduction. Friends, Indian citizenship is not an ordinary subject. It does not depend merely on the place of birth or on any single document. The Citizenship Act, 1955 clearly lays down the principal legal grounds for acquiring Indian citizenship. Without understanding these legal grounds, it would not be appropriate to draw any conclusion regarding citizenship. So, let us now understand these 5 legal grounds one by one. First ground, by birth, Section 3. Let us first discuss citizenship by birth. Even today, many people believe that every person born in India automatically becomes an Indian citizen. However, this belief is no longer correct. The law has changed from time to time. If a person was born in India between 26 January 1950 and 1 July 1987, he or she was generally regarded as an Indian citizen by birth. However, for persons born between 1 July 1987 and 3 December 2004, the law required that at least one of the parents must have been an Indian citizen at the time of birth. After 3 December 2004, the law became even more stringent. Now, merely being born in India is not sufficient. Either both parents must be Indian citizens, or one parent must be an Indian citizen and the other must not be an illegal migrant. Therefore, whenever someone says, "I was born in India, so I am automatically an Indian citizen," the first question should be, in which year was that person born? Second ground, by descent, Section 4. Now, suppose a child is born abroad to Indian parents. Will that child be an Indian citizen? The answer is, possibly, but it depends on the conditions prescribed by law. If, at the time of birth, either the mother or the father is an Indian citizen, and the statutory requirements under the Act are fulfilled, the child may be eligible to acquire Indian citizenship by descent. In certain cases, timely registration of the birth at the appropriate Indian embassy or consulate is also required. In other words, being born outside India neither automatically grants nor automatically takes away Indian citizenship. The decision will always depend on the applicable law. Third ground, by registration, Section 5. The third ground is citizenship by registration. This provision has been made for certain specified categories of persons. For example, persons of Indian origin who have ordinarily resided in India for the prescribed period, or eligible persons who are married to an Indian citizen. However, it is necessary to remove one major misconception. Merely marrying an Indian citizen does not automatically confer Indian citizenship. Marriage may provide eligibility to apply. Even thereafter, the applicant must satisfy all the conditions prescribed under the Citizenship Act, and the application must be accepted by the Government of India. Fourth ground, by naturalization, Section 6. Now let us discuss citizenship by naturalization. If a foreign national has been lawfully residing in India for a long period and fulfills the conditions prescribed in the third schedule to the Citizenship Act, he or she may apply for Indian citizenship through naturalization. However, it is important to understand that applying for citizenship and being granted citizenship are two different things. In cases of naturalization, the final decision is taken by the Government of India in accordance with the provisions of the Act. Fifth ground, by incorporation of territory, Section 7. The fifth and final ground is citizenship by incorporation of territory. If a new territory becomes part of India, the Government of India issues a notification in the official gazette specifying which residents of that territory shall become Indian citizens. Such provisions were applied in the past when territories like Puducherry and Sikkim became part of India. A quick recap of the 5 grounds. So friends, we have now understood that under the Citizenship Act, 1955, the 5 principal legal grounds for acquiring Indian citizenship are: first, by birth; second, by descent; third, by registration; fourth, by naturalization; fifth, by incorporation of territory. Apart from these 5 principal grounds, the Act does not provide any general independent method for acquiring Indian citizenship. Conclusion. Citizenship in India is a legal status. It is determined not on the basis of emotions, assumptions, or common beliefs, but in accordance with the provisions of the Citizenship Act, 1955. If we wish to correctly answer any question relating to citizenship, we must first determine under which legal ground the concerned person claims Indian citizenship. That is the fundamental principle of Indian citizenship law. Thank you for watching this video. If you found this information useful, please like the video, subscribe free of cost, and share your views in the comments. For more legal insights, do not forget to press the bell icon. I shall meet you again soon in the next video. Jai Hind! Jai Bharat!